Good afternoon, dear panelists, the audience, and the organizing team. It's my pleasure to welcome everyone to our expert panel discussion addressing the issue why are Indian parties not choosing Indian institutional arbitration to administer their disputes? I take this opportunity to introduce everyone with the organizers, Let Witness, and Society of Corporate Legal Experts. Lex Witness is India's first magazine on legal and corporate affairs. For over 10 years, since its inception in 2009 as a monthly magazine, Lex Witness has become India's most credible platform for the legal luminaries to opine, comment, and share their views. Society of Corporate Legal Experts is an organization that aims to bring the fraternity members worldwide and the students of law and commercial disciplines to come together for sharing their thoughts on the commercial law, policies, and current trends in these laws. I now introduce everyone with our esteemed moderator, Mr. Chiranjeev Saboo. Mr. Saboo is a dispute lawyer with 3 years of practice. In these years, he has advised and represented, amongst other, energy and resources, construction, infrastructure, shipping and trade companies, to name a few. In doing so, he has participated in arbitration, both ad hoc and institutional, for joint venture, shareholders, construction and consortium disputes, and related court proceedings. He also took part in emergency arbitration and early dismissal proceedings under the rules of SIAC and represented clients in high courts, city civil courts, consumer forums, and trademark registry. I now request the attendees to place all their questions in the question and answer box visible on your respective dashboards. You can upvote and comment on a question as well. We will try and conduct a live question answer round towards the end of the session. You may use the raise hand icon if you are interested to ask your questions live. In the interest of time and more questions, we will prefer questions coming into the question and answer box. Please have a look at your chat box where the webinar help desk will be posting updates regularly. I now request Mr. Saboo to take it from here.
Thank you, Divita, for the introduction. And thank you, Society for Corporate Legal Experts and Lex Witness for organizing this expert panel discussion. A very good afternoon to one and all. Welcome to today's session. Today, we have a very exciting panel for you. Joining us as a first speaker is Ms. Jyoti Dasidar. Ms. Dasidar is a partner at Cyril Amarchand Mangaldas. She has over 11 years of experience in commercial litigation, arbitration, and white-collar crimes. She is also an advocate and record of the Supreme Court of India and regularly represents clients in Supreme Court, High Court, District Court, and various arbitrations. Thank you for joining us, Ms. Dastidar. For our second speaker, we have Mr. Aditya Jalan. Mr. Jalan is a partner at AZBN Partners. He has over 10 years of experience in handling commercial disputes, regulatory investigations, international and domestic arbitrations, and white-collar crimes. He regularly appears before the Supreme Court, High Court, various tribunals, and arbitrations. Thank you for joining us, Mr. Jalan. As a third speaker, we have Mr. Satesh Mukherjee. Mr. Mukherjee headed the disputes practice at Trilegal, which he recently left to start his own independent practice. He has over 27 years of experience in conducting a variety of corporate commercial arbitrations as well as regulatory disputes in diverse industries such as energy, construction, infrastructure, banking, finance, etc. He regularly appears before the Supreme Court, High Court, various tribunals and arbitrations. Thank you for joining us, Mr. Mukherjee. As a last speaker, we have Mr. Amir Nathani. Mr. Nathani is Senior Vice President and General Counsel for UFO Movies. He has over 18 years of experience in the legal fraternity, and in these years, he has worked as a law firm attorney for renowned and global corporates such as Eureka Forbes, LG Electronics, TCL India, Ginger Hotels, Johnson & Johnson, and other MNCs from US, UK, Asia Pacific, etc. Thank you for joining us, Mr. Nathani. Now, before we begin, let us first understand why we are here. Ineffective laws, excessive judicial interference, long delays, high costs, these are some of the traits by which India was known in respect to arbitration. However, India has come a long way from there. India recognized the need for an efficient and an effective alternate dispute resolution system And through various amendments in the Arbitration Act and judicial decisions, India made an attempt to solve this problem and create a robust arbitration friendly jurisdiction. As a result, it can be seen that arbitration has become the default mode of dispute resolution for commercial parties in India. However, in India, arbitration is still synonymous with ad hoc arbitration. Most parties either deliberately or inadvertently choose ad hoc arbitration. And when parties do choose institutional arbitration, they flock to arbitration centers in Singapore, London, Paris, or Hong Kong to settle their disputes. Therefore, giving rise to this question, why are Indian parties not choosing Indian arbitration institutions to administer their disputes? With this backdrop and without further ado, I'd like to invite Ms. Dastidar to share her views. Ma'am.
Hello, good evening. It's a pleasure to be here. Thank you so much. So the topic that I intend to cover is institutional arbitration vis-a-vis ad hoc arbitration. What are the benefits of institutional? Why is it that parties today still opt to go in for ad hoc arbitrations and not institutional arbitrations? So I'll try and, it's a really broad spectrum of issues to be covered, and I'll try and give you a little flavor of everything. So to begin with, what is institutional arbitration and what is ad hoc arbitration? Institutional arbitration refers to administration of arbitration by an institution in terms of its own procedural laws. The institution will provide support for the conduct of the arbitration proceedings, whether in the form of appointment of arbitrators, case management services. You want venues, they'll arrange for that, as well as scrutiny of the final award that is passed. In ad hoc arbitrations, the administration is not carried out by an arbitral institution, but the proceedings will proceed under the supervision of the tribunal itself. In India, we see that the interest in institutional arbitrations, as Chiranjeev just mentioned, is very lukewarm. You know, there are several arbitral institutions. As of 2017, we know that there are more than 35 in India. Despite this, it hasn't really taken off. There are several domestic institutions such as ICA by FICCI. We have the Delhi International Arbitration Center. We have the MCIA in Mumbai. Obviously, parties have access to the international ones, CIAC, ICCL, CIA. There, we are also aware of arbitration facilities that are provided by public sector undertakings, whether it is the PMA under the Department of Public Enterprises. There are various trade and merchant associations. There are city-specific chambers of commerce and industry, such as ASSOCHAM and Bombay Chambers of Commerce as well. So these institutions provide varying degrees of administrative support for arbitrations. They have their own sets of arbitral rules, panels, and so on. But despite the existence of these institutions in India, we see that parties prefer ad hoc and regularly approach the court for appointment of arbitral tribunals under the Arbitration and Conciliation Act. Abroad, however, the reverse is true. There was a study done by the Queen Mary University of London with PricewaterhouseCoopers, which showed that 86% of private disputes were resolved through institutional arbitration, and at least 67% of disputes involving a state instrumentality or state-owned enterprises were resolved through institutional arbitration. In India, it's not the case. Why does this happen? There are obviously a few obvious advantages. Ad hoc arbitrations are suitable for all types of cases, for all quantum of matters. They are generally preferred where the amounts involved are small. Parties also feel that they are in control of the proceedings. They feel that they can control the timelines, and it is relatively cost effective. Parties feel that they have to pay only the tribunal, their own counsel, and the venue and minor administrative sort of charges. One does not have to pay what is seen as the typically exorbitant costs involved in institutional admin fees. However, the disadvantages of ad hoc arbitrations that we see far outweigh the perceived benefits. One, of course, since the arbitration itself is adversarial, if parties have not agreed on arbitration terms before the dispute arises, they are unlikely to fully cooperate. Once a dispute has begun, there is unlikely to be any consensus. It will lead to further delays. Second, even on the issue of appointment of arbitrators, parties generally rely on the good sense of their counsel, on their advice. You want to identify neutral quality arbitrators. But as far as international arbitrations are concerned, parties may not be in a position, if they're not sophisticated parties, they may not be in a position to choose an arbitrator that is technically very sound. If it is a technical arbitration, suppose oil and gas, or the arbitrator should have specific knowledge of law pertaining to, say, Quebec law. So you need for a specific, a trained arbitrator, qualified, technically sound as well. So arbitral institutions go a long way to assist you in this, in matters such as this. Thirdly, the fees of arbitral tribunals are usually decided, at least in our ad hoc arbitrations, are decided in the first procedural hearings. We see that there is usually some awkwardness if there is any disagreement between the parties, or even with the tribunal over interpretation of that first procedural order. But arbitral institutions are an intermediary in this process. Step in, and you do not have to go through any of this awkwardness. It's actually, we've experienced something like this in the past. It is not anecdotal, and you do not want to be at odds with the tribunal, because they are ultimately going to decide the matter. Also, in international arbitrations, we see that there is scope of misunderstandings between parties. Parties come from different nationalities, they're from different jurisdictions, there are cultural biases, there may be a lack of cultural understanding. This may lead to further delays. Parties may not be conversant in certain languages, so all of this creeps in. So in such cases, parties are usually amenable to a neutral party, such as the secretariat of an institutional arbitration, stepping in and sort of administering the process. Also, lastly, the cost savings that parties usually contemplate will happen in an ad hoc arbitration. We see, if it's a recalcitrant party on the other side who constantly keeps going to court, you see that there is, in the ultimate analysis, there is no cost savings benefit at all. So because of these benefits, we strongly advise, as a counsel myself, I would strongly recommend institutional arbitration. So quickly, I'll go through a few advantages. Why should we go in for an institutional arbitration? One, it is structured. It provides an institutional framework which is intended to provide transparency, fairness, and efficiency in the resolution of disputes. It also allows parties autonomy to exercise their choice over several aspects of procedure. There are clear and well-defined rules of procedure. They provide the timelines. There is support of trained staff who will administer various stages of the proceedings, who will clarify doubts, who will step in, who will avert deadlocks. Even the remuneration of the tribunal, which is something of a, can be difficult during ad hoc proceedings. It does not need the direct involvement of any of the parties. Also, there is constant monitoring of the arbitration itself. The secretariat will ensure that there are no delays by any one party. The secretariat will step in to ensure that there are no unnecessary procedural hearings and that adjournments are kept to a minimum. You also have the intervention of a court. Here I'm looking specifically at certain foreign institutional arbitration institutions such as ICC or SEAC, which will not just confirm, replace, or appoint arbitrators. They'll monitor the process, they'll scrutinize the final award, and so on. Also, arbitral institutions regularly update their rules. They have a finger on the pulse. They update the clause itself to reflect current business and commercial realities. Also, certain arbitral institutions provide for a two-tier regime. So a dissatisfied party can actually appeal and get the institution to take a relook at the award in case there's an error and so on. I'm specifically talking of GAFTA or say FOSFA, which have a two-tier regime within the ADR process itself. Uh, Also, the quality of the tribunal is unmatched. As I mentioned, if you want a neutral third-party arbitrator, this is all something an institution can assist you with. So, despite these advantages, why is it that Indian parties still do not choose institutional arbitrations, and specifically those that are based in India? In 2017, Justice B.N. Sri Krishna actually came out with a report, which actually makes for a great read. He spoke about institutions which are prevalent in India, and why is it that parties aren't choosing those. So as per his committee report, he mentioned a few topics which I'll just quickly talk about. One is, of course, the lack of credible arbitral institutions in India. Parties felt that these institutions in India did not really add any real value. There were several misconceptions around institutional arbitration, the cost and inflexibility and rigidity, then the lack of government support, lack of legislative support, and certain judicial attitudes towards arbitration in general. These are obviously some of the issues which we will have to sort of navigate. Um, so I hope this is just a flavor of everything. Thanks, Chiranjeev. Thank you.
Thank you. Thank you, Ms. Dastidar, for these beautifully explained difference between ad hoc arbitrations and institutional arbitrations, and discussing why parties should move from ad hoc arbitration to institutional arbitrations. Um, and to also discuss what are the reasons why parties today are not choosing Indian arbitration institutions. While it is absolutely true that they are not only not choosing Indian arbitration institutions, but they are not choosing institutional arbitration at all in the first place. However, it is observed that parties which are choosing institutional arbitration are opting for foreign arbitral institutions such as SIAC, ICC, LCIA. In fact, India has been in the top 5 non-Singapore users of SIAC for a few years now, and has been the top non-Singapore users of SIAC arbitration in 2019. Also, the number of parties opting for ICC arbitration has more than tripled from 2018 to 2019, taking India to the second position in terms of overall parties. Therefore, this makes me curious as to what are the reasons for parties to not choose Indian arbitration institutions to administer their arbitration. And for this, I'd like to invite Mr. Jalan to share his views.
Thank you, Chiranjeev. A very good evening to everyone, and it's a pleasure to be a part of this esteemed panel. Chiranjeev, you are absolutely right that it's one thing that Indian parties are not going for institutional arbitrations and prefer ad hoc arbitrations, and very rightly put by Jyoti. It is another issue and a more important issue for the matter of this discussion, that even where we are choosing institutional arbitrations, we are focusing on, what I would call the top 5 institutions in the world: SIAC, HKIC, ICC, so on and so forth. In this mix, Indian parties have either forgotten or do not consider the institutional arbitrations based out of India. Well, according to me, the primary reason actually flows from what Jyoti said. Jyoti very eminently identified and listed out the advantages of an institutional arbitration. And most of these advantages actually come out of the rules that the institutional arbitration has. There are more than 35 institutional arbitrations only in India. And the legal perception of each is different. While India is an extremely large country, for the purposes of the market here that we are talking about, that is those clients who are actually interested in looking into institutional arbitrations, A, that themselves is a very low number, and B, for them being lost in the 35 arbitral institutions and the extremely complicated and at times even outdated rules, is something they don't want to go into. The most important aspect that a client looks at when he is deciding or choosing upon an institutional arbitration is that the trust that it would hold uh, when the matter actually comes up for arbitration. See, while these clauses are drafted in a boardroom and they are contained in the agreement, they actually come of use when the going goes bad. When the going goes bad, both parties or all the parties involved in the dispute are already at ends. And at that time, they are trusting and depending on the legal rules and the enforcement of them and the actual practical application of those rules in the scenario. That I think is why most clients have focused more on SIAC or an ICC, the top two examples that Jyoti gave. So we'll stick to that. That what have they done right? The first and foremost, when you go into a dispute, you want to maintain the clock. You want a timely resolution of the dispute. It is important that in India, the perception has always been that while arbitration may be a faster method than the traditional litigation, it is still not time bound. Although the 1996 Act does provide timelines, and well, it has been a very important leap from the erstwhile regime. Still, maintaining timelines is something that Indian institutional arbitrations is not trusted with. That is some place where I think the more foreign institutional arbitrations have excelled in. The other thing that I think is very important is keeping up to date with the current scenario. Now, a lot of these institutional arbitrations in India that I've seen, the rules are, 8 years old, the rules are 10 years old, sometimes even older. And I've actually come across a couple of places where the rules are archaic. Uh, as a contrast with this, you see SIAC every couple of years, it comes out with an amendment to its rules and it quickly updates with with the requirements that are more prevalent, what it thinks could even benefit the ongoing arbitrations. Its experiences from the ongoing arbitrations are actually applied into the rules. And that is something that helps the Indian parties to trust on the institutional arbitrations of more foreign jurisdictions. The third aspect is there is extreme localization of institutional arbitration in India. For example, it's good to have multiple options of India-based institutional arbitrations. I am not for one saying that there should be a monopoly or there should be only one institutional arbitration in India to choose from. It's completely okay to have options. However, when you have 35 of them, it's according to me, a number which is overwhelming and confusing at times, and a lot of the a lot of the institutional arbitrations in India are also factored out because of this, because of extreme localization. So, for example, a party based out of Delhi, they generally don't understand that you do not need to be based out of Mumbai to, for example, opt for the MCIA. And the although it's called the uh, MCIA, but it is not only for Mumbai or for Maharashtrians who have to opt for those rules. I think when it comes to this, some of the international institutional arbitrations have been able to get across and have been able to clarify with their segments in various countries. For example, SIAC has an India office, and it's extremely helpful to actually engage with the India office to get done with a SIAC arbitration. These are another aspects which I think impacts the perception of people to opt for international institutional arbitrations. The last aspect that I actually wanted to touch upon is that cost. Clarity of costs is another aspect uh, which actually helps clients to decide which institutional arbitration they would want to go into. The kind of breakup and the kind of clarity that some of these institutional arbitrations give on the cost aspect Indian rules, a lot of them don't actually go into as much detail of the cost aspect. And when it comes to disputes, I have seen more often than not clients who like that clarity. That's a comfort which is very near and dear to the clients. Uh, Another aspect, and I think I'll end with this aspect, is the kind of arbitrators. Uh, I'm I've kept this for the end because I think it's a very important aspect which actually is being considered more and more. I see the panels which are available with some of these international arbitration centers are, they are extremely technical. They are from advocates, from solicitors, from barristers, from all walks of life. They're very experienced people you can choose from as arbitrators. And in India, unfortunately, there is this aspect, or there's this notion that the first thing that you opt for when you go for an arbitration in India is, let's appoint a retired judge. Uh, well, I'm not saying that there's any fault in doing so. There are a lot of people who profess that view that you should go for retired judges. I, for one, don't agree with that. I, for one, have always believed that retired judges are not right for arbitrations. I am one who keep this in mind, and I've again and again advised my clients to not opt for retired judges. More often than not, what happens is the retired judges have for 20, 30 years practiced one style of handling or matter management. And that style comes involuntarily to them. Even when they are handling arbitrations, they sort of try to bend towards that style of matter management in an arbitration, which kind of diverts from the entire objective of an expedited and a more easier and more comfortable way in which arbitration should continue. This, I think, is a very important factor why more and more people want their disputes to be handled internationally or through international institutions, because I think that you need to walk away from the traditional thoughts in India that a retired judge is a natural choice for an arbitrator. Uh, I think these would be my reasons, or my what I think are the perceptions which need to change for Indian arbitral institutes to actually do better and have a larger share of the pie of the arbitrations that today India is seeing. Thank
Thank
you.
you so much, Mr. Jalan. Thank you so much for these insightful views. And you're absolutely right that all these factors that you've mentioned does affect the confidence of parties in choosing an arbitral institution. And therefore, there is sort of an advantage with the foreign institutional arbitration, because uh, they're able to go through these barriers and create an atmosphere, create an environment which which offers parties that credibility and that stability that parties are looking for while going for an arbitration, Now, this makes me wonder if there are other factors, some other significant factors which sway parties' decision in opting for Indian arbitration institutions to administer their dispute. And to discuss these factors, I'd like to invite Mr. Mukherjee. Um, I'd like to invite Mr. Mukherjee.
Uh, Thank you very much for organizing this wonderful session on a very important topic. Aditya, who spoke before me, placed the nail at the right place and hit it very softly by saying that judges have developed an unique style of matter management. So, well, if I were to call a spade, I would have to say that basically in India, the judicial system works on a very steep hierarchy. It works on the principle that it is a part of the state, and that it does justice to the people and the population. Arbitration does not work on that principle. Arbitration works on flattening the hierarchy. It works on the principle that you're doing a service to the people who have appointed you. And therefore, there is nothing wrong with retired judges at all. but I think we need to build capacity domestically. Our institutions need to build capacity domestically on these principles that govern the arbitration as a dispute resolution process. So one of the things that definitely our institutions lack and therefore must strive to get is more international flavor. So I would think that as a matter of norm, some of the institutions, and particularly the more progressive ones, should consider appointing presiding arbitrator from an international jurisdiction, well versed in common law, well versed in principles of contract which are similar in India with the common law. But they must look to get international presiding arbitrators to come in and, so that the local domestic arbitrators also get a flavor of what happens internationally, and there is capacity building, the work ethic, the speed, the quality. These are things we have all experienced when we do an international arbitration. And it's not actually, I have done an international arbitration in Singapore with a purely Indian panel, and I found the Indian judges to have be no less. But then there are few among in that mold, and mostly our judicial system is steeped in the constitutional jurisdiction. And some of these judges that I had the experience of were hardcore commercial judges, so they had a they had a sense of how commercial matters are to be dealt with. So I think a more international flavor is required to be brought in by the institutions. Interesting data, I was reading a Niti Aayog report which said that 3% of the 126 arbitrators that were appointed by SEAC were Indians, and SEAC administers predominantly Indian cases that originate in India. So we have to recognize that arbitration, international arbitration, and Indian parties have also become sophisticated, have been part of international arbitrations in various jurisdictions. As a part of international commerce, and commerce is becoming more and more global. So while I think in recent times a lot of good effort, good work has been done to build the legal principles and align them with the international best practices, I don't think we've got that same kind of mindset on the procedure. So let me explain a bit more on where we may, lack in terms of procedure. One is that, as again Jyoti said, most of the times our arbitrations just attract the court process, and and we keep, even in trying to do good, like fixing a timeline under Section 29A, we end up giving the jurisdiction to the court. And we are back to court, and the courts have dockets which are massive because of the population that we have, and then the few judges that we have in terms of the population. Even if they have the best intentions, they find it difficult to deal with these questions under Section 9, Section 11, Section 29, which are, a lot of them are things which could be dealt with in arbitration process. So I think the process must also, the courts must start freeing themselves from the arbitration process as much as possible. For instance, now with the judgment in the future group matter of Delhi High Court, they've recognized that emergency arbitration could very much be a part of an arbitration agreement and could be enforced. So I would say that if the parties have agreed on an emergency arbitration procedure as a part of the international rules, Section 9 should not be maintainable in a domestic local court. Similarly, in relation to 11, more and more opportunity should be given by courts for institutions to appoint. If a court appoints a judge and then asks the institution to monitor, the institution's ability to monitor that appointee is much less because he's been appointed by the Supreme Court. Now, whereas if the institution were to appoint, then the institution's moral jurisdiction over that individual would be far greater. That, we appointed you, so, you please abide by the requirements that we as an institution have. So many instances, courts appoint arbitrators and then ask this is the institution to, which, in my opinion, is counterproductive. So I think the courts should start freeing themselves from at least the process arbitration. On the substantive law, they have done a lot of good work, reduce the public policy quagmire, reduce the scope for challenge. And therefore on the process side, they must start also, looking at it and see how they can lay their hands off this process. One of the things that we as a country are probably good at, but we don't do enough as a part of the ADR process, is mediation, conciliation, etc. But there is a reason for it, and the reason for it is that in commercial arbitration, ultimately one party has to pay. So if he can stretch the timeline for which he has to pay without sufficient consequences on the other side in terms of costs and interest, there's no incentive to mediate. So therefore, I think that is the other aspect which the courts must tighten the screws on, and the arbitrators must look at very seriously, is actually awarding actual cost to the against the losing party. We just succeeded in a Singapore Court of Appeal where we got 1.25 crores as cost. So, if I had to advise another client to go for appeal to Singapore Court of Appeal, I would remember that I had received 1.25 crores of cost, which my potential client could end up paying. So I think the imposition of cost on a losing party is something that now, of course, with the amendment in Section 31, there is a lot of detailing on it, but needs to be very, very seriously made a part of all arbitrations in India. Just like, for a long time, what plagued our arbitration was this conflict of interest business where the government appointed arbitrators, the government MD of the company against whom you had dispute became the arbitrator, or his nominee became an arbitrator. Then we got rid of it with the amendment. I think imposition of cost is a very important aspect of any commercial venture. When you start a commercial venture, if you fail, you pay the cost for it. So arbitration, like any other commercial venture, requires to have a downside, and actual cost must definitely be paid. That will actually lead to, the ADR and other mediation conciliation measures succeeding more. And I think the institutions, when they look at administering arbitration, must look at it from both sides. Try to minimize cost by promoting ADR measures, and then try to maximize the penalty of going ahead and fighting a losing case by imposition of costs. So I think that is the other aspect that is important. And finally, I think domestically, when we do all this, we must also match up with the fee schedule of some of the international organizations. If, for instance, our maximum fee under fourth schedule is 30 lakhs. And whether the claim is 500 crores, then also it is 30 lakhs. So, I mean, it doesn't work where, in SIAC, if it's a 250 crore claim, you will easily have to pay about 1.5 crores as arbitrator's fee, another 15 lakhs as administration fee. If it is in MCI also, there are, number of, the fee schedule is pretty remunerative, but at the same time, what happens is that many of the cases which get referred from the High Court for appointment, there the fourth schedule often comes into play. The other thing that we have all experienced over the years as practitioners is this per appearance, per hearing fee, per sitting fee, which makes no sense. I think at least 50% of the fee should be recoverable only when the award is delivered. That's what the international practices are. So I would think that is also an area where the legal community, the courts could actually improve significantly, and to make India a arbitration destination like like Singapore. Most of our cases go to Singapore. Singapore is just 5.5 hours away. There is in terms of now the courts role in interfering with the arbitration process, it is less. It is only that we place too much responsibility with the court, which the court is not able to manage, and that's why there is a problem. So there is a great opportunity. The costs in Singapore are very high. We are much low cost jurisdiction. So there are great opportunities, obviously, but I think in terms of process, we surely need capacity building. I mean, without capacity building, we can't just hope that overnight people will recognize us as a great arbitration destination. Just like when I used to work in law firm, and many of us who work in law firms, and even in corporates, we learn a lot from engagement with people from different jurisdictions. I think the arbitrators could also significantly gain out of that experience. And then, the actual cost and make it a more commercial venture is something that would be important. It's great.
Thank you so much. Thank you so much, sir, for these insightful views. I have two questions for you. One, it has been seen that global arbitration institution keeps on continuously promoting their institution till date, even when they are globally recognized, keeping a dedicated team for their promotion and marketing, establishing local offices in different countries, organizing events and participating in various seminars, none of which is seen to be done by Indian arbitration institutions that extensively. Do you think this lack of interaction with the community and letting people know that they exist is a big factor in their inability to attract parties? One. And the second question, which I want to ask you, is that it has been seen that at the end of the day, lawyers and law firms are the people who would advise clients when drafting drafting arbitration agreements. So, do you think some sort of confidence in lawyers and law firms by these arbitration institutions would go on in a long way in advising clients to put an Indian arbitration institution as a boilerplate agreement in different agreements as a mode to administer their disputes?
So I think the first question and the second question are also linked in some way, and basically, as I said, arbitration is a commercial venture, part of the international commerce. So we need to market it just like any other commercial venture. Goes without saying, and we need to deliver the quality and continuously improve to deliver the quality of service that just like any other commercial venture does, just like a law firm does, just like a corporate does. So it must. But as I said, the mindset is still, of dispensation of justice from ivory tower. And it is not as, I don't think many of us still, look at justice dispensation as a service which is done to the community. So therefore, when people charge high, we start saying, oh, how are we charging so high? And because it's a public good. The arbitration is not a public good. And so that and therefore, our institutions must come with that fervor of a commercial venture. And that question is absolutely linked. And if it is a commercial venture, why should anybody support them by having clauses in agreements which has these institutions when they don't deserve it? Maybe the government can, like Maharashtra government has, and it's a good step, can look at government contracts. At least it's a far better situation than having the MD appoint and the arbitration being held in one of the cabins or the rooms in the public works department. So it is a far better thing, and so let the government do that. But at least commercial lawyers and law firms are not going to recommend just because there is an institution which is there, unless they are able to measure up to the quality which we have come to experience internationally.
True. Absolutely, sir. Thank you so much. Now that we have identified some of the important factors due to which Indian parties are not choosing Indian arbitration institutions to administer the disputes, the question that pops in my head is, what is the advantage that India would have if parties start choosing or opting for Indian arbitration institutions to administer their disputes? And I would like to invite Mr. Nathani to share his views on this.
So, first of all, I'll tell you where my experience come from arbitration. I mean, during the early stages of career, this was around 2002, 2004. 2, 3 examples, and they're on the experience part of it. I had a negotiation with Microsoft, which was happening, and as always, we at that time also foreign agreements. You have jurisdiction which is out of India. They had I think arbitration panel as ICC in Singapore, and if you see that time they used to have an annexure in the agreement which says that if you're based in India, X, Y, Z, other countries, then your arbitration is at ICC Singapore. If you're in certain jurisdiction, then your arbitration is X and Y place. That was the first trigger point. The second trigger point, which I remember, this was late after 2006. I was in a conference with Justice Dalveer Bhandari. Justice Dalveer Bhandari is presently the judge of the International Court of Justice. And he said to one of the senior counsels, I will not name it, he said, stop taking matters because you're delaying arbitration now. The laws have come, but you have taken so much arbitration that your arbitrations are getting delayed. And this was right from the mic towards the first row where the senior counsel was sitting. Number one. So it was in the lighter sense. But number 3, in a United Kingdom court, a commercial court where the appeal went, that commercial court judge, the first has this lower court taken about 6 months to decide a commercial dispute. Because if you take 6 months to decide a commercial dispute, how will the business function? And I was having a hearty laugh because if you file section 11 at that time in any high court for appointment of an arbitrator, your hearing itself will come after 6 months to 1 year, just for appointment of an arbitrator. All right. So arbitration process is yet to begin. One time we were standing in the court and just in a lighter tone, we said, yeah, the arbitration is begin, but arbitration is presently, there's some noise coming somewhere. We were standing on the court, and on the lighter side, what we said is that arbitration has become like an airline which has a takeoff time but does not have a landing time. So these are the 4 experiences I come from. Now, if India wants to become a very competitive jurisdiction, all right, it has all the intellectual capacity to do that. We had the law since 1996. It's high time. I still remember, I think, many of the sentences which probably everyone would have said. I worked in a corporate, and my problem was that I need to book a Taj hotel. I need to book a conference room. I need to have best of the facilities, cars, etc. Those things have been, a cost has been always triggered down. And that has really affected the reputation of arbitration. So the key point, number 1, is about the reputation of arbitration. Now, today, whenever I speak about arbitration, the first thing which comes to the mind, if it's a big arbitration, the first thing, and I can give you several examples, having worked with all the big corporates. We had some big dispute. I was in Reliance, Ekta Kapoor, then Raymond, Singhania family dispute was all in the newspapers. I do remember the instances which came up to the mind while we were discussing these options. All right. I get a call from a hotel, 5-star hotel in South Mumbai, saying that you have appointed X person as an arbitrator and you have booked a room, but normally that arbitrator was an ex-judge. And they said normally he prefers to stay in this particular room, all right, which was a level 1 above the room which I was booking. So, that has really tinted the reputation of arbitration. I think we need to put the arbitration reputation in place, number 1. Now, I am presently seeing India going way above those particular parts. We all know that this is the cause of this is the root cause of the problems which are there. So while I go towards the root cause, what is the advantage India will have? All right. Now, as a country, we have been now promoting India as an arbitration hub. We have these arbitration panels, which have institutions which have come up. The changes were brought in the arbitration law itself in 2015, the amendment. The aim was to achieve that speedy and efficacious disposal of the matter. All right. So these are one of the two contentious issue. One is the speediness of the issue, and one is the efficacy. Now, when you say efficacy, you put down on the costing efficiency as well as the arbitral efficiency in that. Now, since 2014, after the new government came in, it has been a priority for the policymakers to make India as a better investment opportunity, as well as to have a hassle-free trade mechanism. All right. It's not only about arbitration, even at all levels, digitization happened, etc. So that's our goal, that we want to have want to have India as a business-friendly jurisdiction. At the same time, in India, lawmakers are also focusing to provide better provisions of enforcing contracts and quick and easy means of resolution of dispute. India has progressed towards improving its global perception of doing business in India. According to the World Bank rating also on the ease of doing business in 2018, India ranked about 100 out of 190 countries, which is a great sign for the Indian government as well as the administration part of it. In 2016-17, India was also among the top 10 economies which has been improving and reducing complexities about their regulatory processes. So there is something to celebrate while we are working on it. Arbitration became one of the celebrated dispute resolution mechanism because of the factors that when the Indian law came into force, we said there is a flexibility and a unique process, which means you don't have that civil procedure code evidence and you don't go into the zone of 2 years, 5 years and 10 years. There's a uniqueness to the process and we wanted to materialize that uniqueness. In the process, when the law came in, the distinction happened between ad hoc arbitration as well as institutional arbitration. Now, perception wise, what happened is that, like speakers were saying, that you appoint a retired judge or you appoint any arbitrator. Ad hoc arbitration became a perceivedness that it's not a very reliable because there might be some gaps in it. It may turn out to be very expensive. At one point of time, there was a concept of caucus, which is still there, where you sit down with the parties, and while the arbitrator is discussing with the other party, you as a lawyer will see your watch because the billing is by the hour. All right. Now, what distinction happened in institutional arbitration? The institutional arbitration gradually ramped up their reputation. If you remember, in last 15-20 years, the institutions which was very well known abroad was International Chamber of Commerce, ICC. Dubai came out with a package saying that, all right, your air tickets to hotel, to arbitration, to everything will be taken care. Dubai International Center for Arbitration came up. AAA, American arbitration, was very expensive. People would not prefer. AAA was basically at one point of time suffering the same situation what we are suffering in ad hoc arbitration. Then came up your SIAC, Singapore International Arbitration Center. Now, because of this reputational, like somebody was saying here, that, you know, they've put in a lot of efforts to put an office there, marketing, you receive emails. Singapore International Arbitration recently set up an office in New York. What happened is that because of this professional marketing as well as the approach and the rules which they had, and some of the good cases were there. In fact, SIAC is not well known right now also. When the Future Group and Reliance Group dispute came up, SIAC was also well known when the Tata and Docomo dispute came up because of the telecom issue. Now, they gradually turned out to be perceived as more reliable, predictable, and acceptance. This is the three criteria we are also looking. If India wants to have a jurisdiction friendly or a friendly jurisdiction for arbitration, we need to create that trust, reliability, predictability, and acceptance. Now, how do we do that? Number one, first is that we create the reputation, inbuilt reputation. That is, it's an efficient system, whether you consider ad hoc, whether you consider institutional. You develop those systems in a manner that your arbitration awards are completed. Law provides you a provision of 1 year, 2 year, etc., and then parties can extend or something. But point is that suppose if you have an arbitration award which is passed in 6 months, 8 months, 12 months, it will make a lot of difference to it. So number one, we need to gain reputation on those grounds. Number two, enforcement of those awards. What is the one-up position which Singapore Arbitration Center got in India is that the legislature never contemplated emergency arbitration. In fact, the Law Commission report rejected emergency arbitration. Singapore International Arbitration passed an emergency arbitrator award restraining Reliance and Future Group from proceeding with the deal. The award got challenged in the Delhi High Court. Delhi High Court did not give a stay on that. So there is an enforcement advantage to it. Number three, your arbitration rules really make a difference. So those arbitration rules which are published in the booklet, the user-friendly rules which are there. For example, you can also exchange your statements of claim by an email. You can correspond in many regards. So those are some rules which are available, which are user-friendly rules. We have institutions like CAC, ICC, Dubai International Arbitration, Hong Kong Arbitration, etc. These are reputed because of these factors. Number four, your administration itself is very important. The advantage of institutional arbitration when you set up when you want to look upon India as an arbitration friendly jurisdiction, the administration of those institutions is also very important. You have trained staff to administer those arbitration. They will ensure that the arbitral tribunal is appointed immediately upon the request being received. Advance payments of the fees and expenses are received. Time limits are kept in mind. It's not an open door policy. The arbitration is run as smoothly as possible. These are various factors which go on to build your reputation as a arbitration friendly jurisdiction. For India, the fifth important part is that when we have arbitration friendly jurisdiction, there is a supervision provision. What is a supervision provision? We remembered at the time, 20 years back, when any ICC award is passed, there is a scrutiny of that award before it is passed on to the parties. There is a board which is sitting there in confidence to look that whether the arbitration award, which has been decided by the arbitrator or arbitrators against one party or in favor of one party, has it covered every angle? Is there a lapse in that? Is there any gaps in that, etc.? Those scrutiny happens. And therefore, if you see all these awards of the institutional arbitrations, these orders are very reputed by themselves because they have been cross-checked in addition to the arbitrator who is sitting there on the seat to decide the matter. Number six, as we all pointed out, we always speak out in this heavy words saying the quality of the arbitral panel. All right. I would not use the word quality of arbitral panel. And once we were having a debate also where our moderator pointed out today that you don't require judges. We were debating out that what is this trend? Why the present judge is appointing a retired judge? Those discussions do came up. The two reasoning which was given for that is that number one is that the judges have a trust in the fellow judge. Number two is that those judges have dealt with all these matters so well for so long in the courts that they understand that, how this matter will be finally decided. All right. So this was the argument in favor. The argument against it was that that if the matter is about engineering or any specialty or about internet or e-commerce, do you require an arbitrator who should be an expert on that? Do you require a technical person, or do you require a generational lawyer who will be able to understand what is an hyperlink and what are the synonyms which are used in this business? All right. What I really feel about the quality of the arbitral panel is that we have all these uh, all these learned arbitrators who should be trained enough in the arbitration. Like, for example, when I speak about myself, I'm a trained mediator. I've been trained by trainers who have gone from one of the best institutions in mediations in London, and they've trained me. So when I sit for mediation, I know that it is about the reality check, and therefore my first goal is to listen to the parties. So I always feel, irrespective of the position of the person should be trained enough to handle the matter. It's not the past experience of sitting on the bench. You should be a trained arbitrator in the matter. You should be a trained mediator or a conciliator in the matter. That's the pre-qualification for it. Number one. Number two, if the matter is about construction, maritime, contract, trade, commodities, internet, e-commerce, we should, when the time requires, have an expert appointed for that particular panel. All right. These are the two critical observations I have seen where matters are then debated before the appeal court, saying that there is a lapse in the award because the engineering factor has not been taken into consideration. No judge, no lawyer or arbitrator, unless he's an engineer, is expected to know the answer from that angle. All right. So one is, the panel should be a trained, educated in arbitration panel. They should be certified irrespective of the position the person is in. And number two, when you require an expert, we should have that expert in place. We should not have an ego issue against the other person being advising me on that arbitration panel. The seventh is about the remuneration part. So earlier we used to say the charges are very high, the cost is very high. And then we found a diplomatic language of saying that the remuneration is too high. All right. Remuneration has always remained a factor. Whenever you go for an arbitration, you look at the cost and benefit of it. If you think that this foreign institutional arbitration is cheap, it may not be as cheap considering the amount which is involved. But if you're a big oil company, those amounts don't matter to you. But what is the reasonability is always a question which I've seen. But the perception what people have for Indian institution is that the cost is very high. We have to remove those perceptions somehow. All right. Because senior counsels do charge, arbitrators do charge. Keeping the Indian factor in mind, we'll have to come out with some bridging part of it, because arbitration success has not happened because there is a lot of amount of cost, irrespective of the 5-star treatment which is expected. I think somewhere down the line, we'll have to bridge that gap. That gap has still remained open for the last 15 years. Number 8, 2 more to go. Number 8 is about the speed. There are a lot of arbitrations which I've seen. I'm just speaking out of my experience, and I will always speak out of my mind. There are some arbitrations which can be completed between 3 to 6 months. Unfortunately, I've seen some arbitrations being continued, even in that case, for more than a year, 2 years, etc. Now we have a threshold. So we try to finish in that threshold, or we take 6 months extension because that's mutually granted. Next 6 months, we are a little sticky about it because we think that the High Court may put a ruler on our knuckle. But point is that somewhere down the line, people have to think about timelines. We should not only think from one side where there is a forum of lawyers and arbitrators. We should think on the other side from a business standpoint also. I feel in a guesstimate time, we should have arbitrations which should get completed between 6 to 9 months. I think we should not enlarge it. Even normal arbitrations are really taking time. And that's very questionable, because then again we come back to the remuneration part, where parties feel that, because of the cost involved, the arbitration was little dragged on. The ninth part is that there are some great default processes in the rules of the institutions which are available, where if the party doesn't appear upon being called upon, the tribunal proceeds for hearing. In case of SIAC, emergency arbitration matter was in the limelight. There were two arguments put by Future Group. Number one, it says that emergency arbitrator was never conceived by the legislator, and therefore this order should not be upheld. The stay was not granted. Full-fledged arbitration has been initiated now. All arbitrators have been appointed. And second, the Delhi High Court reflected on the FDI rules may have been probably breached. But point is that there are some great procedures which are required in our arbitration process. Why not do we feel that we should not have an emergency arbitrator award? I'll give you one of the finest examples. There are two cases which are there. Bank guarantee law is very clear that even if you have performed all your contract, the opposite party can still encash your bank guarantee. You will have to go to the court, get an arbitrator appointed, and then recover the money. All right. Number two, there is a lock-in period in an agreement for 7 years. The party has breached the contract. The lawyer has advised them that even if you breach, there is no stay order which will be granted by the High Court. We will see in the arbitration and what happens after 2 years. If there was a provision for emergency arbitrator, I think things would have looked differently. So maybe from a justice point of view, I would have preferred that there is some provision which is available for emergency arbitrator, because the law, if you see today, the courts have been very diligent and they have refrained themselves from interfering with the arbitration unless there is a patent illegality or a public policy matter. And I think this step would have been useful at that point of time. So in my closing remark, which is my 10th point, is India has all the capabilities to provide a perfect destination for institutional arbitration, considering the intellectual power, rules, administration, supervision, quality of arbitrators, remuneration, cost, and speed. We only need to portray these capabilities into a jurisdiction which has a reputation in arbitration. And I think that's very important because it's a 96 law. We are already in 2021. It's about 25 years. I think it's high time that we become more efficient in our efforts. That's from my side. Thank you very much. You're on mute, Chiranjeev.
Chiranjeev, you're on mute. Please unmute your...
Hello. Thank you, Mr. Nathani, for these views. And I absolutely agree with you that to attract parties to Indian arbitration institution and to make India an arbitration hub, there will have to be collective efforts made by all the stakeholders, including government, including legislatures, judiciary, arbitration institutions themselves, lawyers, everybody. And once we start changing our perception and changing our approach towards arbitration, we will definitely walk in the right direction to make India an arbitration hub. Now, this brings me to my last question, which is what are the factors? What would it take to make India an arbitration hub? What are your suggestions which should be implemented with an immediate effect to promote Indian arbitration institutions and to promote India as an arbitration hub? And I'd like to invite everyone to share their suggestions, starting with Ms. Dastidar.
Hi, thank you. So two really quick points. One is that if touching upon really what Zameer was also talking about, if the institutions that administer arbitration in India, if they can provide credible case management systems, if they can have credible case management services, which will include not just ramping up facilities and something which goes beyond, clerical or secretarial assistance. They need to see which of the issues can be bifurcated into an award to be given initially, which of the issues can be decided, by the mutual cooperation of parties, which issues, will require oral evidence, which needs documentary evidence. So a real, a credible system has to be in place. And my second point, which is really touching upon what Sitesh also said a little earlier about the role of the executive, the government. Yes, we've seen in Maharashtra, there's a boilerplate template for institutional arbitration, so on. But I think if this can be done, not just it should be done also for PSUs. It should be done for any sort of state instrumentality. There's a lot of, say, oil and gas arbitration, so that should be a boilerplate template, so as to encourage Indian institutional arbitration. Thank you.
Thank you, Ms. Dasidar. Mr. Jalan.
Yes, I think another aspect which I think Sitesh touched on was that you need to accept that dispute resolution by way of arbitration and institutional arbitration more so is a service. The professionalism aspect of that service, the aspect that the end goal is a timely resolution of the dispute, and the aspect that at the end of the day, if amounts are being spent by both parties, whether it be towards the facilities, whether it be towards the arbitrator fees or towards the institution fees or towards the lawyers, is actually towards the end, that is there is a resolution, and when that resolution occurs, that's when a bulk of those fees should be accepted. This will, I think, at least motivate the arbitrators, the institutions to actually expedite the resolution process. And once this attitude or this service-oriented aspect of commercial dispute resolution will become more amenable and acceptable in the country, I think the institutional arbitrations in the country will, by themselves, to some extent, start seeing the light of day more and more. In addition to that, I think effective professional marketing is another aspect which plays a very important role. Well, I understand the limitations of marketing in our industry, but even with those limitations, there have been a lot of institutes who've successfully carried it out. There's no reason that domestically we cannot do the same, or the Indian institutions cannot do the same.
Absolutely. Thank you so much, Mr. Jalan. I'd like to invite Mr. Mukherjee.
Going a bit more granular, I think touched upon quite a few things, and so have my co-panelists in great detail. It's been a very enlightening conversation. I think a little more granular, the apart from the case management system, which is important, or maybe as a part of it, I think the physical infrastructure, one of the delightful things in arbitrating in SIAC in the early days was that, you didn't have to quarrel with the judge and the witness as to what he was saying, where he or she was saying, because, the transcription service was online and on the screen. So, so this is something that will be a, a very, very significant service that the institutions could provide as a part of that, the infrastructure. I think the broad basing of the people who do arbitration is very important. I can't complain. MCI has appointed me in their very second case as an arbitrator, but I think they should broad base the pool of arbitrators by including local practitioners, by including international practitioners. So what could happen is when we sit in panels with international practitioners, they will carry the performance of some of us back home, and then SIAC they'll share it with international institutions. So people who come in contact will probably get a chance to be in international panels. So that will basically be a great exposure for the local arbitration community. And I think thirdly, very important, like we have specialist tribunals for many things. I'm not advocating a specialist tribunal, but I think we should have very specialist arbitration courts earmarked at all levels, including from district court to civil court, where they only take up arbitration matters, so that we are able to deal. Some of these things will have to be dealt with by the courts only. Nobody can substitute, even if we take out large part of the process. But they'll be able to deal with it quickly without being contaminated by the massive docket we have in various other types of cases.
Thank you so much, Mr. Mukherjee. I'd like to invite Mr. Nathani.
Yeah, so from my experience, I will just point out four. Number one is the cost, which has always remained a contentious issue. Somewhere down the line, we'll have to bridge the gap. Number two is about the speed of the system. I think wherever possible, we should increase the speed. People are looking forward to it. Because you are an arbitrator, because you are an institute, probably doesn't happen much in the institutional part, because it's an ad hoc arbitration which is happening. People don't express to it, but there is a frustration, because I come from that corporate experience of 18, 20 years, when I sit down with my CEO, he will tell me there's a cost, it's going on for last 2 years. It's a little embarrassing that, some small dispute also takes so much time. Point is that my reasoning is that it would have taken more time in court, but that's not a great answer for as a fraternity. I think I'll expect more speed on that. Number three is the efficiency and efficacy in the management of arbitration. These are all critical observations for last 18 years of experience. And number four, which is a bold statement I want to make, we should have compulsory arbitration, and we can keep a threshold to it. But I think somewhere down the line, we should start. Right. That's from my side. Thank you.
Thank you so much. Thank you all for these insightful suggestions. And I'm sure by taking these steps as suggested, we will definitely move towards the goal of making India a global arbitration hub. Now, with this, we have come to an end for today's discussion, and I'd like to quickly conclude the session, and I'd like to sum it up this way. Undoubtedly, there has been a sea change in the way arbitration is viewed today. And
Chiranjeev, sorry to interrupt you, Chiranjeev, Akshay from Lex Witness. We have a few questions in the Q&A box. I'll request Zameer
sure,
sir,
Akshay,
if you can take up the questions.
I would have taken it post this. All right.
Okay, sure, please. I'm sorry, I misunderstood you.
But we can definitely take the question and answers before the conclusion. We'll only be able to take 3 questions for today. The first question is that if an award of 2016 has been objected to by both parties under Section 34 at their respective district courts, which have not been able to dispose of the petitions even after over 4 years, can the suffering supplier seek setting aside by agreeing to the buyer's payer under Section 34, and thus be free to initiate fresh process for re-arbitration without any limitation problem? And anybody could answer this question, whoever feels like. Can I please request?
Sitesh, you want to answer this?
I suggest, one of the law firm partners can take that.
Yeah.
Question.
You can send the invoice to Chiranjeev.
So I'll take it.
Yeah.
So the thing is, theoretically, can you do away with an arbitration award? Both have already challenged it. It's been pending for a very long time. The practical answer is you're not going to get any closer by reinitiating the arbitration proceedings. If you're actually reinitiating the arbitration proceedings, whatever distance you travel, you're actually canceling even that and going back to day zero. So I don't think it is an effective way of actually coming at a resolution. You're turning back time, and after say 18 months of the arbitration again happening, if you again land up before the district courts in 34, you're again going to wait for another 4 years anyways. So I think you would rather go for procedures. You may file applications or applications to expedite the 34 process to try and instigate the courts to or impress upon the courts as to why they want to or should hear the 34 application and dispose it off. That, according to me, would be at least my suggested approach. And even district courts, although I understand that the district courts do not realize the timeliness of an arbitration proceedings as much as possibly the high courts do. But if impressed upon, the district courts would realize and possibly take up the matter to resolve the delay that is being caused.
Thank you, Mr. Jalan. The next question is for Ms. Dastidar. The question is, you have discussed the distinction between ad hoc and institutional arbitration and how institutional arbitration have an edge over ad hoc. But on the other side, this added advantage comes with some exorbitant cost. Thus, despite being better, parties are constrained to go for ad hoc arbitration just to reduce the cost. Therefore, the question is, how do you suggest the parties to go for institutional arbitration in such cases, or what do you suggest?
Okay, so I'll try and answer it. I think all four of the panelists have spoken about institutional arbitrations, and of course it has an edge over ad hoc. In India, it hasn't really taken off because parties have the impression, that the institutional arbitration is rigid, parties will not have any say over the timelines, costs are prohibitive, because the impression was always that an institutional arbitration will have to be seated abroad. That is not the case. I mean, we've done multiple institutional arbitrations, even if it is administered by LCIA or SIAC, we've had them very much in India. So the fear of having to carry a truckload of people all the way to Singapore or London, none of that exists. Plus today, with the pandemic, everybody's moved towards a virtual sort of hearing of matters. When you will get excellent administration, when there's excellent case management services being given, whether in India or abroad, why is it that you would go in for an ad hoc arbitration? I think the benefits of institutions administering arbitrations far outweigh ad hoc. In fact, at the moment, without saying more, I know I'm doing an arbitration which has gone on for 3 years. It is a massive matter, but I really wish it was an institutional arbitration. By now, the matter would have been over, and I think both parties are left high and dry, because it needs supervision, and that is something you can't approach the tribunal itself. It needs supervision at all sort of levels. So I would really recommend an institutional arbitration.
Just on that experience, after finishing an international commercial arbitration under SIAC, I got a domestic arbitration on which we had to negotiate fees. So people were negotiating on a per appearance fee. I very politely told the panel that you may charge SIAC fees, no problems, but please follow the same disbursement schedule as SIAC, which is at the end of the award, please take most of the money.
So no, I just want to add here. See, if you see the 3 criteria which I spoke, fourth was compulsory arbitration suggestion. The 3 criteria were cost. Number 2 is your speed, and third is your case management. If you see ad hoc and institution arbitration, the difference you will find if you debate it out, they will say the case management is very efficient. Number 2, speed factor also you will get a check mark, because there is an efficiency attached to it. If you see both sides on ad hoc arbitration, you always complain that it has taken much longer than we expected. And the case management efficacy, of course, because there's an individual administration which is there. So these 2 criteria are there, and the third criteria is about the cost. If you are able to achieve this particular 3 criteria, which is appreciated, you will achieve your success as an arbitration-friendly jurisdiction. This is where we are lacking, and that's where the distinction between ad hoc and institution has gained 2 up because of this factor. That's very candid statement from my side.
Thank you all. Due to paucity of time, we are not going to take any more questions. I'll sum the entire debate quickly, and then we'll have to end the call. So to sum it up, undoubtedly, there has been a sea change in the way arbitration is viewed today. And lately, the steps that are being taken are definitely the steps in the right direction. However, there is still a lot of work to be done, as discussed by our panelists, and to make India an arbitration hub like Singapore or London. And therefore, it needs to be borne in mind that you don't become an arbitration hub overnight. You will take the time that is needed. What is important is to focus on what you can do, and the catalyst of which will be a combination of government initiatives, judicial and legislative support, a proactive arbitration institutions, and a conducive commercial mindset. As discussed, basically the environment that is that attracts parties is one where there is a sense of there's a sense of certainty, predictability, and stability. And therefore, once you start following this recipe and get all the ingredients right, this will send out the right message to all the stakeholders, and I'm certain that a robust institutional framework will follow. With this, I would like to thank all the panelists for their insightful suggestions and for their time. It was a pleasure listening to you all. And I can safely say on behalf of our audience as well that we thoroughly enjoyed it. I would also like to thank Society for Corporate Legal Experts and Lex Witness for organizing this event. And a big thank to Aditi to coordinating with everybody and making this happen. Thank you so much.
Thank you, Lex Witness, and thank you, Aditi, and everyone.
Thank you, everyone.
Thank you so much. I personally thank Chiranjeev for keeping the entire session so interactive, and all the panelists for being a part of it and sharing and imparting your knowledge. Thank you so much, and thank you, Lex.
Thank you.
Thank you.